Roland Mumford with Mumford.law. There's a lot of things that piss me off. And one thing that pisses me off is when a sheriff's deputy or a police officer or such other law enforcement officer charges a young child at a school with autism or any other type of special needs disability. I'm going to speak on this issue unscripted. I don't have anything in front of me that I'm reading. And then after what I'm about to discuss, it was here locally, I'm going to go through and show you what laws are in place that you can file against a sheriff's office, possibly against the school board and the officer for charging a 5-year-old for assault because it was a manifestation of a disability and not behavioral. But let me give you a little bit of history. I'm a father of an autistic child. I'm an uncle to 3 autistic children. And I've had my son in private school he's in 7th grade now, and he's been in private school every year except kindergarten and 2.5 months at this particular school in White House, Tennessee. I had represented an 8-year-old a number of years before who had been arrested by the same Sumner County Sheriff's Department, who had been put in an orange jumpsuit, put into a jail cell, put into a restraint chair, and I'll leave my comment about how the court handled that matter for the first couple hours, but he was finally let out. But I'm not going to discuss any more about that. It's all over the internet, that story. You can look it up. But here we go again. And then today I find out that the SRO or a sheriff's deputy charged a 5-year-old child because he carried out in a classroom. I'm not sure all the details of the manifestation because that's what I call it, not behavioral. But apparently it was concerning. When you deal with children who have autism or special needs and you're dealing with a manifestation of disability, not behavior. It's a lot of people, when I read in these comments, especially in this Tennessean newspaper article, they don't seem to understand the difference. They think it's behavioral. They don't understand that when an autistic child has a manifestation, it's a medical issue. They don't choose to be that way. And this sheriff's department in Sumner County has a history of abusing the rights of autistic children and young adults. Google it, Sumner County Sheriff's Office, and see what comes up. If it's not arresting young adults that have autism with DUI, and in fact were never intoxicated, or allowing young autistic children to leave the school and they can't find them, and then they put in a false narrative of what occurred, and then a sheriff's deputy actually has to come in and put a police report that contradicts the school's narrative, or if there's other general allegations of abuse of autistic children that have occurred over the years. I know because I've represented some of them in federal court, and there's other examples you can read in any kind of Google search that comes up. So today I learned that a 5-year-old is charged for assault. A 5-year-old autistic child for assault. A 5-year-old child with no disability can't even form the legal intent to commit a crime. So how do you charge a child for assault? This goes to the lack of training on that SRO, that police officer, the sheriff's department, and I believe it's deliberate indifference because too many actions have been called up over the years about this sheriff's department. But this sheriff's department, this sheriff loves to be on TV looking for special needs children when they go missing and the cameras are there. Look at me. We're looking for the missing autistic child. But when it comes to abusing the rights of autistic kids, let's see if he shows up in front of the cameras today. He always hides from them before, and he gives some kind of pre-written statement instead of being held accountable and being transparent. Now, anybody that has any education on disability education or the rights of special needs kids in schools, there is a form. It's usually part of the IEP. An IEP is an individual education plan for a student that has a disability. And the school has to adhere to that per federal law. And there's also usually another form, and it looks like it's a graduated level of intervention. When a child has a manifestation, you use the least restrictive intervention, and then it increases depending on the circumstances. Now, I don't know how bad this manifestation was. I don't know if he was throwing chairs around, if he was hitting other kids, if he was throwing things. I'm not sure. It can maybe possibly raise to a level where you have to use certain types of a restraint to put on the child from hurting himself and property and others. But I don't even know that was necessary. But let's assume that it was. How do you go to the extreme of charging a 5-year-old, disability or no disability? How do you do that? How, as a sheriff, do you allow your officers to be ignorant like that to do that? I hope that this family finds the right attorney and sues the hell out of this sheriff's department and this officer that charged this 5-year-old. There's no excuse for a 5-year-old who can't even understand what he's doing without a disability. He sure as hell can't understand the requisite intent to commit a crime arising out of a manifestation of a disability. So let's talk about what laws protect children against civil rights violations. That apparently is what occurred today. All right, let's take a look at this. So what kind of 1983 civil rights lawsuit can you file if a school resource officer or a police officer charges your autistic child for having a manifestation of a disability? Well, let's zoom in here. All right. So let's talk about a 1983 claim. You can sue any person acting under color of law. Most of you know that. So let's talk about what kind of law here would be involved with an unlawful arrest and seizure of a child with a disability. One, you're going to have an unlawful seizure, arrest without probable cause. You're going to have excessive force if the physical restraint was unreasonable given the child's disability. That's a very important point. We've talked about these cases in my other videos. Graham v. Connor, Tennessee versus Garner. Graham v. Connor and Tennessee versus Garner. Two very, very important cases. Now, Graham, those are the three elements that we've talked about in other videos. That's involving excessive force claims. And Tennessee versus Garner, that's looking at unreasonable seizures of violating the Fourth Amendment. Now, remember, sometimes the law, you have a detention, you can have a seizure, you can have an arrest. And sometimes the law and the lines can be blurred between a seizure and an arrest. They can often be the same, but sometimes they're not. Now, you could have a 14th Amendment substantive due process or an equal protection violation claim. If the arrest or treatment was constant, shocking, or discriminatory towards your child because of the disability, you could allege violation of substantive due process rights. Again, that's an arbitrary deprivation of liberty or an equal protection violation. And what that is it's the targeting or the differential treatment based on that disability. Now, let's talk about failure to train, a municipal liability claim. Hell of a claim against this sheriff's department with all the history. You can include that Monell claim against the school district or police department if they fail to train officers or staff to interact properly with students with disabilities, and this failure was the moving force behind the violation. And I think there would be a hell of a claim here, given the history of the sheriff's office. Let's talk about companion non-1983 claims. I have litigated IDEA, that's Individual with Disability Education, a federal law, Individual with Disability Education Act, IDEA. And then I've also litigated the ADA claims under parallel claims in federal court for children and against school districts. I don't do as many before, but if the right case came along, we might consider it. Now, the ADA covers discrimination by schools and police departments, public entities, that is. Now, the officer or school failed to reasonably accommodate a child's disability during the arrest or disciplinary process, you're going to have a Section 504 Rehabilitation Act claim. All right. And that's because it covers programs receiving federal funding. And that's where it's most important. And most public schools, if not all, receive public funding, federal funding, that is. So the discrimination solely by reason of disability, that's what you're alleging. Now, these claims are often stronger than a pure 1983 disability claim because courts have well-developed standards under ADA and Section 504 for police misconduct involving disabled persons. Now, here's some examples of some cases. In the 10th Circuit, I remember this is JH versus Bernalillo County. That was an autistic student arrested by an SRO. 1983 claim for unreasonable seizure not allowed to proceed. The Sheehan versus City and County of San Francisco, 2015. Discussed police ADA obligations when dealing with mental illness. And then there's a 2010 case, TW versus School Board of Seminole County, 1983 and 88 claims for improper restraint and arrest of an autistic child at a school. The relief that you can seek, compensatory damages for emotional distress, trauma, or physical injury, punitive damages against individuals, that'd be against the officer, not the sheriff's office. Now, in Tennessee, you would be able to sue the sheriff's office as well as possibly the county for a 1983 claim, because here sheriffs are not considered constitutional officers. Whereas, let's say in Georgia and others, they are considered state constitutional officers, and therefore, because of the 11th Amendment immunity, you wouldn't be able to go after them, so you'd have to sue the county. And you get declaratory injunctive relief requiring training or policy changes, and attorney's fees under 42 U.S.C. 1988. Now, The summary of a typical complaint would be that plaintiff brings this action under 1983 for 4th and 14th Amendment violations under Title II of the ADA and Section 504 arising from the unlawful seizure, arrest, and discriminatory treatment of the child, a student with autism whose disability-related behaviors were misinterpreted as criminal conduct by defendants acting under color of state law. So those are the claims that you could possibly have. I hope you share in the outrage of what occurred. If you want to share your contempt and your concerns over what happened in a respectful and a courteous and professional manner, not being rude or disrespectful, then, the school board for Sumner County in Tennessee, they have school board members that have ways to contact them online, and there's public phone numbers. And if you want to contact the sheriff's department at a non-emergency number, their public number that accepts calls from the public in a professional manner where you want to redress your grievances per your First Amendment right in a peaceful, courteous, and professional manner that does not in any way, that is not inappropriate, then that is your right to do so. But do not do anything inappropriate at all. Thank you for your time. Please click like, share, and subscribe.